Hi, I'm Anindya Basu. I currently practices as an advocate, specializing in criminal law in various district and sessions courts in West Bengal. Today, I'm going to give you a brief overview how a criminal trial takes place in a court. Though there might be an actual difference in an actual court case proceedings and in a mock trial, but it will help you in various aspects of a mock trial like framing of charges, examination, cross-examination, arguments, 313, judgment, etc. I'll give you some explanation of the queries which has also been raised by some of your participants in the mock trial, which has been brought to me by Harsh Agarwal. Now, I will also try to cover them up as much as possible through this session. So, when a lower court trial starts, like it starts in a magistrate court or a sessions court, the lower court or a trial court is the first line of defense for both the complainant or a accused person to seek justice. In a trial court, the magistrate or a session judge have an important role to provide justice. They are the first line of defense for both the integrity and the criminal justice system. The harassed and the distressed litigant also face the first line of defense, that is the magistrate or the session judge, to seek justice. The trial court have the power to acquit the accused or convict the accused also, even before a trial. And it also gives reliefs to various litigants on the basis of the evidence reached at a stage by discharging the accused if it's a fit case. Now, for preparation of a criminal case, certain document has to be read very carefully, and several times this has to be kept in mind at the time of the trial. So what are those documents? The documents are an FIR. The FIR is a key essence of any criminal trial. Now, why an FIR is an important document? FIR is an important document just because FIR contains the essence of the case. When a complaint is being lodged, after lodging a complaint, the complaint is then treated as an FIR by the investigating authority. Now, when an information report is being read carefully, certain things has to be kept in mind, like the name of the accused persons, the sections under which the case has started or the case has been initiated, and the brief fact of the case. So after that, the things comes is written complaint. So a written complaint is the complaint which has been lodged by the complainant or the victim or an officer or any other person connected with the case. So the written complaints has to be typed or it has to be written in hand by the person concerned. Then comes the charge sheet of the case. Charge sheet is the final report which is submitted under section 173, which contains the list of accused persons, the section under which the charge sheet has been submitted, the list of witnesses. If anything has been seized, then the column of the seized articles has to be filled up. Then comes the seizure list and any other medical reports or injury reports as according to the case, or if there is a chance of a post-mortem, then the post-mortem report as necessary. It is the duty of the prosecution to examine his witness according to the case when a case comes before a court of law. It has to be kept in mind whether that witness has any relationship with the complainant or it has some relationship with the victim or not. The history of those witnesses or the person who are coming before the court of law as a witness has also to be traced. Like if they have some previous grudges, or if they are neighbors, or if they are local people, that has to be kept in mind. Certain things that are also very necessary is the date, time, and place of occurrence, without which a criminal case doesn't stand at all. A date, time, and the place of occurrence are very necessary. Statement under 161, 164 are also very necessary. Statement under 161 is the statement which is made before a police personnel, and a statement under 164 is made before a magistrate. It's a deposition which is given between closed doors between the person giving the deposition and a magistrate, and it has to be written down, and the magistrate signs the paper and the victim also, without any undue influences. If it is necessary in the case for any chemical report or any forensic report, that report has to be gone through very carefully. Now, when the criminal cases ends, then there is a procedure under section 313. 313 is the stage when the entire witness stage has to be explained to the accused persons, so as to explain him what has been deposed against him before the learned court. That is a key part to let know the accused that certain things can be used against him regarding the said case. That procedure can't be can be neglected, and it is a very key stage regarding a key trial, because it is very necessary to use the stages of 313 in an argument, to use the necessary procedures on an argument based on 313. Now, how a crime is being committed. First, a crime is committed in a place by some people or a person concerned. Then that crime has to be reported by a victim or a complainant himself or herself, or any other person connected to the case, or a police may suo motu report a crime. If in some cases, if a police is not taking any report, or is not taking the complaint of your crime, then the person can seek the help of a magistrate and file a petition before the magistrate under section 156 of clause 3, so as to direct the police concerned to take the complaint as a FIR. Now, when a complaint has been treated as an FIR, the FIR is made under section 154 based on necessary investigations and other documents. Now, when an FIR is being lodged after necessary investigation, arrest might or might not be made. When an arrest is being made, an arrest memo is very necessary. It has to mention the place where the person has been arrested, and it has to have the signature of the arrested person. The magistrate, under the power of section 190, takes cognizance of an offence when he receives the complaint, the copy of an FIR, and other arrest memo and other documents. And the case starts from that instance. Now, when a person has been arrested after necessary investigation, if anything is being seized, the seizure list has to be prepared. And there are certain key features of a seizure list. Seizure list has to be made before 2 independent witnesses, and that 2 independent witnesses has to sign those seizure list. Now, when a person has been arrested by a police officer, that person has to be produced before the nearest court within 24 hours from the date of arrest and from the date and time of arrest. There are certain scenarios when an arrest might not be necessary, as per various judgments that has been passed by the Honorable Supreme Court. When an arrest is not necessary? When the police officer is on the ground to believe that a person might be issued a notice, and after issuing that notice and the police officer gets satisfied of the statement which has been given to him, and on satisfaction of the statement, he finds that there is no reason to arrest or detain the person accused in the case, then he might issue a notice under section 41A of CRPC, so that the accused may seek a bail with that notice before the learned court. There are reasonable grounds to believe that the accused might not need to be arrested. Thereafter, when the accused comes before the learned court, if from the police custody or with a notice of 41 CRPC, the court, after looking at the case diary and the process of the investigation, might grant a bail or might not grant a bail. So, what happens if the bail is being granted? Then the accused gets an interim relief, and if the bail is not being granted, then the accused is remanded to a custody, and that custody is either via judicial custody or a police custody. Police custody is needed when there is sufficient grounds for investigations and other progress of the case. And a judicial custody is when there is no need of an investigation. A judicial custody can be granted to an accused person. Sometimes, in some cases, accused may be given a custodial trial if the crime is very heinous. For instance, in that case, the court might direct the investigating officer to file a charge sheet for speedy disposal of the case by keeping the accused in custody. In that case, the officer has to submit the charge sheet under section 173 by following all the procedures, and the case has to be transferred before a learned ACJM, before a learned magistrate court or a sessions court for trial. Under section 207 and 208, magistrates are required to supply a copies of those documents, like the copies that are necessary to proceed a case. That is the FIR, the statement recorded by the police under section 161, or the statement recorded by a magistrate under section 164, and medical document, etc., that are necessary for proceeding of a case and the charge sheet. That document has to be given to the accused person for the benefit so as he may find justice, so that he may proceed before the appropriate court of law. Once the case has been transferred, the trial starts to begin, and it is a duty of the prosecution to write down everything in detail in the instant case when the cases are being transferred. When a magistrate commits a case under section 209, the court of sessions and the accused persons, the court of sessions direct the accused persons to appear before him, either from the judicial custody, or if they are on bail, on the same bail application, they are being produced before the learned court, and the prosecutor is required under 226 to explain the charges against him, and the matter is then transferred to an appropriate court for trial, where the magistrate has to explain, where the prosecutor has to explain him under section 226 the case or the charge that has been levied against him. Now the question comes, framing of charges. How a charges is being framed when a matter has been transferred before the court for trial. Under section 228, when the judge, after considering the records and the documents submitted by the prosecution and the submission of the prosecution and the defenses, if he thinks that there is reasonable grounds and presume that the accused has committed such offense, the judge accepts the charge, and if the matter is being tried by a magistrate or a sessions court, as the case may be, and accordingly the charge is levied against him. Upon consideration of the charge, if the documents on the records and the case and hearing the prosecution and the defense counsel, if the judge is of the opinion that the accused has no sufficient grounds to proceed against the case, the accused has not done such necessary action, or he has no evidence at all, the judge has the power to record this statement, and under section 227 might discharge the accused from the instant case without even having a trial. When a case that has been transferred to a court of sessions, and after hearing the matter, the court of session is of the opinion that the charge that has been framed against him might not come under the purview or might not be triable by a sessions court, then the court of sessions might transfer the case to the chief judicial magistrate or any other magistrate with the rank of first class, and he shall direct the magistrate to try the matter, to accept the matter and try the matter, and according to the procedure laid down in the trial. Now, when a charge is being read over by the prosecution and the accused persons are present before the court, it is the duty of the defense counsel to provide sufficient knowledge to his accused so as he pleads rightly before the learned court. The accused has the right to plead guilty, or he has the right not to plead also, and he may not plead guilty as well. So it is the duty of the defense counsel to guide him accordingly. Under section 229, the accused might plead guilty, or he might not refuse to plead. Then the court under section 229 has a discretion to plead the accused guilty and has the power to convict him. But in such cases, it has to be kept in mind that the judge or the magistrate has to apply care and his judicial mind and shall not act arbitrarily. And the judge also has to keep in mind, when he is pleading such guilty or not, that there is no such undue influences or there has been no such voluntarily or there has been no such indictment, or otherwise there has been no provocation at all from any other person, otherwise it will be violative of the provision of Constitution of India. Now, what happens when a accused pleads not guilty? Now, it is the defense of the it is the duty of the defense to understand the case and guide his client properly, and to make him understand to plead not guilty. Then there is a chance to call upon the witnesses and try the matter according to the charge sheet. Now, how witnesses are being called? Under section 135 of the Evidence Act, the order of production and examination of witnesses has been explained under section 135 and 135. Now, the prosecution has the power to refresh the mind of the witnesses. The defense counsel doesn't enjoy this liberty. The prosecution has the power to refresh or to make him remember the acts that has been done during such instance when the actual incident has happened. It is the duty of the prosecution to examine the witnesses. The motto of the counsel should be to unearth the truth and to explain the facts as per the case that has been filed before the court. Now, three things that are essential for a successful examination in chief. The prosecution has to equip himself with necessary facts of the case, and he has to keep in mind all such facts and circumstances that are necessary to proceed with the case, like the FIR, the charge sheet, the written complaint, etc. Now, the examination must know what are the base advantages of proving the case beyond reasonable doubt. Now, he should know that what are the things that are necessary so as to displace the foundation of the defense counsel. And lastly, the examination in chief, when it has been done by the prosecution, he has to know that a witness has to state himself the facts, and he has to get down to the bottom of it and has to understand the case and let the witness state before the court on its own, apply his own mind, and allow him to state the facts that has been that had already happened. It is the duty of the prosecution to guide his witness also. How to guide a witness? The prosecution has to provide him motivation. He has to guide the witness by giving him enough power. He has to guide a witness who is being shy before a court. He has to guide him by giving him such motivation so that he doesn't fail, he doesn't lose his nerve. He has to also understand the nature and character of such witnesses also. How he will understand the nature? If the witness is too smart, he has to understand that. If the witness is too simple, he has to understand that. If the witness is too imaginative, he has to understand that, and has to act accordingly, and has to adapt himself, and has to guide the witness in that manner, because the prosecution only enjoys the privileges of making or remembering or refreshing the witness. The prosecution also has to keep in mind that he has to maintain some code decorum also. Like a prosecution cannot start interrupting a defense counsel when he is proceeding on with his cross-examination. In the like manner, a defense counsel cannot also disturb the prosecution. He might give objection to some uncertain points. Now, it has to be kept in mind that under section 136, the judge has the power to determine the admissibility of any evidence that has been given before the learned court. So, a prosecution has to keep in mind, and the defense counsel both has to keep in mind, what shall be deposed before a learned court. It has to be kept in mind for a prosecution that no leading questions can be put before a witness when he is doing his examination in chief. Leading questions are not allowed in criminal trial. An examination in chief, it has to be kept in mind from the prosecution side that an examination in chief is only and always should be connected to the relevant facts of the case. But here, the defense counsel enjoys something, some liberty. The cross-examination does not need to be restricted to the facts which are stated or testified in examination in chief, or which are there in the entire FIR or complaint. To unearth the truth, it is the duty of the defense counsel to break the witness and bring out the truth and take the answers favoring the accused persons or his clients. Now, there are certain things that has to be kept in mind when a examination in chief is being done. Examination in chief has to be done in such a way that it might reveal the truth, reveal the essence the case has been framed. The art of examination in chief is to put question in such a way that you reveal, that the witnesses reveal the entire facts and whatever the prosecution wants to know, or whatever the prosecution wants to be deposed before the learned court. Now, the questions has to be framed very carefully. How the questions has to be framed? The questions has to be framed in such a way that they are necessary to the case. How they are necessary to the case? It will be so often that they has to be put deliberately. A prosecution should never put rapid questions to his witnesses. He has to keep in mind that his witness has to depose before the court the facts that has been stated therein, that has happened in the incident, that has happened at the time, that has happened during the occurrence of the case. The prosecution should also keep in mind that if the prosecution starts to move quickly, or if the prosecution starts to starts to give quick questions, or has the intention of making the examination in chief short, then he might have the chance to lose the case, as relevant facts might not be deposed. So the questions has to be framed in such a way that necessary and important evidences are deposed before the court. Now, what are the duties of a prosecution? The duties of a prosecution is to put all such necessary questions so that the defense counsel has to keep in mind that every such questions that are been kept inside that are been deposed in this instant case are putting or making the case even stronger, and are all against the accused persons, and are making the prosecution case strong. Now, what are the hints that can be given to a witness when a prosecution is doing his examination in chief? The prosecution might start with the story that let the witness allow to start the order in which the incident took place, the time in which incident starts happening, the time in which the incident starts happening, the events in order which has been the events which has happened on that day, the order which it has happened. He has to let the witness depose before the court in that manner. It is also advisable here that the prosecution might not lead him, but will allow him to state him accordingly. Whatever he has to do before the accused comes on dock to depose the witness. He has to prepare his witness beforehand. It is also admissible for the prosecution that he has to let his witness state in his own way, and he has also it is also his duty to see necessary precautions has been taken. He has to guard his witnesses. If the witnesses goes off track, he has to then alert the witnesses by stating some facts, by stating him or by alerting him. It is a skillful examination in chief always renders his witnesses in such a way so that they don't become a prey of the cross-examiner. And last but not the least, you have to be prepared. The prosecution has to be prepared for the attack of the cross-examination. The prosecution has to prepare himself for the questions or the questions that could have gone against him, which would have been put by a defense counsel before the witness, and which could go against the case. He has to prepare himself for that too. Now, when a witness is giving his witness before a court, it is the duty of the judge to write down such deposition. The deposition should be written. Under section 276, every court should write down, and under his dictation it has to be written, and it has also to be signed by the witnesses also. So the prosecution, during the entire part, when his witnesses comes before the court, it is his duty to honor the truth. He has to prepare himself when a complaint comes before him. He has to prepare himself when a victim comes before him. He has to prepare himself in that manner. His preparation should be different according to the witnesses. If the witness is a complainant, then necessary document has to be exhibited before him, like the written complaint, the FIR. If he is a victim, then medical documents has to be exhibited. If he is a police personnel, then the formal FIR has to be exhibited. The seizure list has to be exhibited. If he is a seizure witness, then seizure list has to be exhibited. If he is a medical personnel, then injury report or any other medical documents. If there are need of a chemical report, then the medical expert opinion, the chemical person who has reported made the chemical report. If there is a forensic report, then the person of the forensic concern authority has to be examined. It is the duty of the prosecution to examine every witness and has to prepare himself accordingly for each and every witness that are there in the instant case. The duty of the prosecution doesn't end when the examination in chief or the cross examination ends. It is its duty also at the time of 313, when the accused is being explained what are the depositions or what witnesses have deposed against him also. The prosecution has to keep every such points and notes of such depositions, of such procedures of 313, as the 313 is a very key element for argument and judgment also. Because in 313 stage, the judge explains the matter to the accused persons, explains what has been stated against him by the witnesses or what are been stated in the instant case by the witnesses, and that thing might be used against him in the instant case. So it is the duty of the prosecution to keep each and every thing in tab, note down everything. Now it is the duty of the prosecution to keep in mind certain key aspects of a 313 stage. Why a 313? A 313 gives him enough info or enough in evidences so that it can be used by him at the stage of the argument. If the accused is not being is not being refreshed or is not being guided by the defense counsel at the stage of 313, then the prosecution can take advantage of that situation. So the prosecution has to keep a tab of every stage, has to keep tab of every evidence that has been given before the court, not only the part of the examination in chief, but also the part of the cross-examination, and also to keep in tab every other documents, and to see the discrepancies or the corroboration or the lacunas in there, and present his argument before the learned court accordingly. The judge, after hearing such evidence, might find no evidence against the accused person and release the accused under section 232 and give him an order of acquittal if he thinks there is no such evidence that has been committed by the accused person. Under section 311, at every stage, at the stage of inquiry, trial, or any other proceedings, the court may examine any person if he thinks that person is necessary for or his witness is essential for the decision of the case. Now, if a judge thinks fit that a judgment of a conviction is needed, then the judge under section 235 can produce a judgment of conviction or a judgment of acquittal, both. A judge may also release the accused on the ground of probation of good conduct if he thinks that there are certain necessary grounds, or as the case and nature may be. Under section 360, he has the power to release the accused on the ground of good conduct. Now we come on the part of defense. The part of defense is very essential in a case. A defense counsel has to keep every instance, every deposition, every statement made in the instant case. A defense counsel gets to question the witness only when the examination in chief has been completed. There are certain key features the defense counsel has to follow. The defense counsel has to be very attentive. The defense counsel has to be very informative. He has to hear every question, everything that has been deposed. He has to take note of everything that has been deposed before the learned court by the witnesses and draft them accordingly, and then tally them with the final printed form so as to find if he has, so as to see there are any mistakes or any human error. Though it has to be kept in mind that cross-examination is not limited to the part of examination in chief only. The defense counsel has the power to explore, to unearth the truth, to get the favorable answer that is necessary for his clients, that is necessary for the benefit of his case. Now, the defense counsel has to keep in mind certain factors. He has to keep in mind the investigation, how the investigation has been made, the facts, the circumstances, the incident of the case. The lawyer has to be very sharp and cunning. Moreover, he has to become as a detective and work as a detective to unhide the truth, to get information about the witnesses, to get their previous history, to get their previous narrations. How it works is like, if the witness has deposed something before the learned court at the time of examination in chief, and at the time of cross-examination, he might depose it in a different manner. Both might not be the same. Some witness might, the complainant might have stated something like the date or the time of occurrence, or same occurrence of specific date, but the victim might state that same date of occurrence or the date of crime or the incident wrong, or a different date. So it is the duty of the defense counsel to keep such thing in tab. He has to become very informative in such manner. Now, the defense counsel also has to keep the same facts as the prosecution has to keep in mind. The FIR, the written complaint, the statements under section 161, 164, the charge sheet, the medical reports if they are, the seizure list, etc. He has to study them very carefully. He has to find out if there are any lacunas in the instant case, because everything is there inside the FIR. The whole thing lies inside the FIR. Any lacuna in the FIR or any mistakes done by the investigating authority or the prosecution will give him a chance to prove his case. So the defense counsel has to go through the entire brief a numerous number of times and has to find certain mistakes, lacuna, and to keep in mind all the necessary facts of the case. Now, certain things has to be kept in mind. What are to be kept in mind? That are questions. What kind of questions can be put before a witnesses? So what kind of questions can be put? The questions can be critical questions. The questions can be vital questions. The questions can be reluctant questions also. Why critical questions are the questions that are necessary to the case, which you might not avoid. But there are vital questions also, which if it goes wrong, might turn the entire scenario, and the witness and the case and the accused might get convicted also. So it is the duty of the prosecution to see that these questions are being divided and they are put accordingly in the manner. He has to apply his own mind, and he has to apply his nature, and has to see the character of the witnesses and put these questions accordingly. He has to put reluctant questions before a witness also, so he has to understand his nature and character, how he reacts. There are certain probable questions which a defense counsel always has to ask, like when the case has been committed, like the date, time, place, and occurrence. He has to go through all these things, covering the date, time, place, and occurrence. He has to find lacuna by putting questions before the witnesses. He has to ask questions regarding the topography, like where the case has occurred, the place of occurrence, the area where it has occurred, the neighborhood of that place, the scenario of that place. He has to ask questions of that. He has to ask questions to the witnesses regarding their literacy, whether they are literate, whether they are illiterate, or whether they are literate to the point that they can sign, or whether they are illiterate that they can sign but they can't read whatever they are written in the facts. They might be aware, or they might read English, or they might not read Bengali. The defense counsel has to go through all this by putting questions before the witnesses. The defense counsel also has to keep in mind by putting certain questions that whether the witness who has stated before the learned court in his examination in chief, what he has stated, that it's not a hearsay, whether he has not heard the thing and has deposed before the learned court. It has also be kept in mind that the witness, when he comes before the court, he has narrated the incident and at various other places or not, or whether he has narrated the incident to the court before, or he has narrated the incident to other peoples also. Some questions might be narrated to it, some questions might be like, have you ever narrated the same story as you narrated before the learned court to anyone or before any other forum? The defense counsel might ask also that did police ever come to you or ask you any question regarding the said incident, or did you ever go to the police station? As the case may be, the defense counsel has to understand what question and he has to ask and when he has to ask. He has to understand the fact that what he has to ask and when he has to ask. He has to understand, and he has to understand the timing, that when he has to put such questions. It is the duty of the defense counsel to break every witnesses who has deposed or given evidences against his client. It is the duty of the defense counsel to find loopholes in the investigation, to find difference in the statements, to find difference in other documents also. If the defense counsel thinks that there are certain questions that has been raised by the prosecution is not favorable, he can raise objections to that. That objection has to be noted by the judge also. But in that way, the defense counsel also has to maintain a decorum. In that way, he cannot disturb the prosecution counsel also. It has to be kept in mind for a defense counsel that a prosecution cannot never lead a question. If a leading question is being asked, then the defense counsel can always raise an objection by stating that a leading question has been asked. Questions to the complainant, questions to the victim or the medical counsel or the investigating officer or the medical personnel has to be asked in such a manner and has to be briefed in such a manner so as to prove his client's innocence. The defense counsel can ask questions to the complainant regarding how they are, how he has drafted, whether he has drafted the complaint by himself or whether it has been drafted by any other person or not, whether he can read and write the what has been stated in the written complaint, whether he knows what has been stated in the written complaint. If he has not written, who has written the written complaint? Is there any endorsement or not? If the victim is there, he can ask the victim that at the time and place of the incident, whether he knows he has seen the accused person or not. If he has been a victim, whether he has reported such injuries to the medical professional or medical professionals or not, whether he has a injury mark, whether he has given such reports of injury before the learned court or not. If he has been a victim, whether he has reports such incident to any other person or not. The defense counsel has to keep in mind every such fact. If he is an investigating officer, the defense counsel has to ask some necessary questions. The questions will be like how he has investigated the matter, whether he has investigated according to the police rules and regulations, which has to be followed by a police officer during investigation of a matter. If he is a medical personnel, then he has to apply his medical mind. Certain medical journals has to be followed. He cannot give his own opinion in his own manner. He has to follow his medical procedure and medical journals and provide his opinion also. The defense counsel has to go through each and every stages of this. After the examination part is done, and if there is necessary, if the court thinks there is necessary need of recalling any other witnesses, and if the stage of 313 where the complete evidence which has been relied in the instant case by the prosecution side and the defense side has been explained to the accused person by the judge himself, if the court thinks he might call for a witness, and when the court is explaining the stages of 313, it is a duty of the defense counsel to make and to understand his client in such a manner that his accused is being prepared, that his accused states or gives answer to every such questions in a manner that is not that doesn't goes against him. Whatever questions might be asked, he has to give it in such a manner that cannot be used against him. The judge will state each and every deposition that has been given in the entire case, and that has to be explained elaborately, and the judge will also ask the accused if he has something to say, though it is the duty of the defense counsel to explain him and to make him understand what to say before the judge. And if he asks whether he wants to give any witnesses, then it is also the duty of the defense counsel to prepare him that whether if he needs a witness or not. If he doesn't need, then he will say that that he will not give any other witness of his own. Now, the defense counsel from the beginning until the 313 and till the stage of 313 of CRPC has to keep note of everything. He has to keep note of the entire facts. He has to keep note of all the examination, all the cross-examination in chief, the exhibited documents that has been exhibited in the instant case, and has to make a brief note of argument by keeping in mind all the different aspects, by keeping in mind the differences that are there in the statements, there in the examination and cross-examination, and the corroboration that are there in the evidences, and prove and thereby give his argument and submit his argument accordingly. Now, after argument, the thing is very same as how a case is being proceeded on by a judge. The judge, after listening to the same, if he doesn't find that there are enough evidences to prove the accused guilty, he might discharge the accused, or he might not discharge, he might acquit the accused under section 232. But if he finds that there are certain things that he might which goes against him, he might give a judgment of a conviction or a acquittal under section 235 of CRPC. Is the same. Now, in this instant presentation, I try to give you about an overview how a cross-examination or examination takes place in a trial court, how a trial court functions, how you will be able to keep yourself up to date, or how you will act in your mock trials or not. My presentation gives you an overview of the procedures relating to the magistrate trials and the session trials. They both act in the same way. The trial that takes place in this court will give you an overview how the CRPC provides an opportunity of free and fair trial to every accused persons or to any other persons. And it also sees that there is no undue delay during investigation and trial also. Everything has to be taken care of. My presentation also gives you an overview that how you may act, how you can prepare yourself, how you can brief the case, how you read through it, what are the key things that you have to keep in mind, what are the necessary points that you have to note. And the first and foremost thing, to be a trial court lawyer, you have to stay alert at the time of the examination and cross examination. Even a single way of even if you're not alert in a single moment, some things might go wrong. In this sort of cases, the judge always has to keep his judicial mind and apply his judicial mind, and has to ensure that accused is given a free and fair opportunity to hear and defend the case also. The judicial mind also has to be applied by the judge, and has to see if the accused has necessary evidence against him, the judge may convict him also. Thus, it is up to the judge and up to the defense counsel to present their case and to hear accordingly. Now, thereby I state that my presentation here is over, and thank you. If you have any other questions and queries, you can revert me back through the mail that has been given to me, provided by me through the presentation below.